Any mention?
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 9, Your Lordship. I humbly pray that this matter be taken after 3 weeks, Your Lordship. Item number 9. It's a joint request, Your Lordship.
Here for the respondent.
Respondent 3 and 4.
I'm for the petitioner.
No objection.
No, Lordship.
2 weeks.
3 weeks, Your Lordship.
Why 3 weeks? 2018 matters. 2 weeks. The prayer made on behalf by. So it's okay. Yes.
Much obliged, Lordship.
Supplementary causes. Item number 1.
Please, Your Lordship,
Yes.
this is a washing of an FIR. A very trivial matter, it's a very small matter.
Again, POXO matter.
No, Your Lordship. Your Lordship,
May I
the
just interrupt, Your Lordship? Your Lordship, my friend is basing his application for quashing the proceedings on a compromise agreement, but that compromise agreement has not been attached with the petition.
Is it?
Your Lordship, it's mentioned in the charge sheet because it's part of the record.
But then we
It's
have not
mentioned
seen
in
the
charge
terms
sheet.
and conditions.
that
I'll show it. I'll show
that
it.
has
It's
to be
reflected
brought
in the
into
charge
the
sheet.
record of this court.
Yes, yes.
If
Lordship,
you want to say that there is a compromise,
yes,
you have to show us.
yes, yes.
We have to
It's
see
there in the
the
charge sheet. It's
contents.
reflected very clearly in the charge sheet what has been done.
Where is the charge
I will
sheet?
just show that part, Your Lordship.
What is
Charge
the
sheet has
offence
not
alleged?
reproduced the compromise agreement.
What is the offence alleged?
It's
323
just,
and 324.
323,
Not a
324.
very.
Yes,
Not the
324 is
previous one.
non-compoundable. We've already appraised before the lower court
324 is
also.
not comparable.
Yes, it is
Non-compoundable.
non-compoundable.
So we have already filed an application. That application was rejected, not inclined because non-compoundable. So we have come. So the petitioners here are complaining.
Where is your
alleged-
where is your
I'll
compromise?
just
Just
show
show
it.
us.
I'll show it. Lordship, please, can you have page? Page 32, Your Lordship.
Yes.
Page 32. We have,
32 is some statement,
yes,
I think.
towards the end, Your Lordship. It's in the page, Your Lordship.
Page?
33.
32, Your Lordship. Starting from 32. Towards the end, Lordship.
There is a
On
reflection of
16,
compromise.
yes, on 16/9/2023, the complainant, Shri so-and-so, submitted a petition dated
No, but then
September
this is
so-and-so,
your
a withdrawal
this
and
is,
also a compromise deed, Your Lordship. Can you see it?
just a minute, just a minute. This is a statement, isn't it?
Yes, this is a charge sheet. He has
No,
reproduced
but
the
then
statement.
it is reflected as a statement of somebody, isn't it?
No,
Who
towards
is this,
the end. This
who
is
this Manoj Gurung?
Manoj Kurung is one of the
So
accused.
this is a part of his statement.
No, this is not part of statement. This is a charge sheet. Can you come to the previous page, 31? This is where the charge sheet starts. Page 31.
That is all right.
This is a
That is
charge
all
sheet.
right. But then in the charge sheet, the statements are reflected. That is what-
Reflected. Yes.
So that is what this is a part of his
Yes.
statement only.
No. Can you come towards the
Anyway,
end?
you place before us this compromise. There is no
Yes.
problem. Who are the petitioners here?
The petitioners, number 1 is the complainant. Number 2 and 3 are the alleged victims. 3 and 4 and 5 are the accused. There's another one accused, but he is on training, so he couldn't be a part of this proceeding.
Why they are represented by one counsel?
Yes.
Why? Why?
At the very
Why complainant and accused? Why? They are in
because
collision.
following the filing of the
But
FIR,
it becomes difficult. You see how to determine this compromise is voluntary.
it is voluntary. It is
How-
reflected in the charge
We
sheet.
cannot go by your statement.
But in the charge sheet
See,
everywhere.
the problem is that when complainant and accused is represented by one counsel, it becomes difficult to determine the voluntariness. Because you will be saying, we see what is required for getting relief here.
Lordship, if I may,
Okay,
Lordship.
see, otherwise a counsel should not represent the complainant and the accused. That is what the problem is. How do you know you have not obtained it under coercion? Or
Not at all. Not at all. It's not at all a question. Immediately
But
after
why-
filing
how do
the
we
FIR,
know it?
in the Thana itself,
Do you expect you will see? Will you make say? Will you say yes? You'll never say yes. At all, if there exists any force also, coercion also, will you say that yes, it is there? You'll never say. That is what the problem is. So before you draw your strategy, at least think of that part.
even the application before the lower court also, we have appeared before the trial court. They have
We'll
jointly
do, madam,
filed.
we'll do one thing. We'll issue notice. You have your instruction also. And the next day, let him produce the.
Compromise agreement.
Compromise.
And also, Your Lordship, as Your Lordship
Or
has
you can,
pointed out,
if you
whether
can
you
produce
can
it next week, we
appear
can,
for all of them.
or before issuing notice also, you can place on record this thing. We can have it tomorrow.
But tomorrow again will not be possible unless the record is called because I've applied
No,
for the
you have
certified.
to open. See, this is your case. This is your case. You have to procure that.
Yes, but it's in the record. It's not with
So
me.
you obtain, apply for a copy.
If the record have been called, then I can just flag it.
Your case. It is your duty. Try to understand.
But
You are
tomorrow-
basing on compromise. You are basing on compromise.
Let it come on Monday. I'll try to get it by tomorrow.
That is what. That is what.
Because, Lordship, if I may please submit, Your Lordship, from the very beginning, immediately after filing the FIR, both the complainant, the accused, and the victim, everyone went to the Thana to settle the matter. They filed the petition to withdraw the FIR by the complainant and also the compromise deed. They were under the impression that the matter has already been closed. But the accused, the petitioner
We
number
understand.
4 and 5 received a
We
summons.
understand. You see, maybe what you are saying is history. But these are all factual aspects. You see, that is what the problem is. Okay. So anyway, just place the compromise. Let us see. Let us see what is the compromise.
If not
You
on
should have
compromise,
made it a part of record.
yes, I'll do that by Monday. Your Lordship.
Well,
Because I've seen it.
praise for. No, just a second. Just say at the outset, Learned AG has pointed out that this application has been filed seeking quashing of the Matan rating PS case number 86/8 of 2023 under section 323/321/334 on the basis of a compromise, but the petitioners have not brought into record the said deed of compromise. Stop. Mr. Marpan, learned counsel for the petitioner, makes a prayer for listing the matter. No, Mr. Marpan also learned counsel prays for grant of some type for praising the deed of settlement stroke compromise before this court. Stop. Prayer allowed. List on.
Monday.
You'll be able to get it by Monday.
Let it be.
List after a week. List after a week.
Leave less after a week.
List after a week.
Lordship.
Item number 4.
May it please, Your Lordship. Lordship, the learned DSGI is on legs, so I humbly pray before Your Lordship to kindly take up this matter at the end of the book.
I've gone through the record, my lord, and I find, my lord, it was not proper for us to file a writ criminal, my lord. We want to withdraw this, my lord.
Mr. SD.
We are withdrawing.
Learned counsel on instruction. Learned counsel for the petitioner on instruction submits that petitioner does not want to press this application and prays for withdrawal of the same. Stop. On prayer being made, this writ petition stands dismissed on withdrawal. Yes.
No liberty.
We have not passed any order of liberty, so where is okay?
You want to?
You want them to give liberty? That should not be your concern.
Daily costless. Item number 1.
Person, you do not want perhaps the matter to end. You become habituated with it. 4 or 5 appearances. Yes.
But only difficulty, my lord, what they'll do, my lord. Because in fact, I prepared all the compilation to show the conduct of the party, my lord. But now, because they are caught, they've withdrawn, my lord. Now I don't know what they'll do.
So you prepare for that.
See, Mr. Day, once he came yesterday, he appeared. You could understand that he will do something. You could understand the mood of the court. That maybe cost to be imposed. But anyway,
So they're judicially, now the extrajudicial, they'll do something, my
now
lord.
it's a simple withdrawal.
No, we'll come to judiciary. We'll come very heavy this time.
That is your thing. How you chalk out
Without
your
liberty, you can come.
Yes, yes.
My lord.
We'll see. my lord.
Yes. What is this item?
May it please your lordship. Lordship, in this matter, we have forwarded a copy of the affidavit in opposition filed by the private respondent. We are still awaiting instructions, my lord.
What is this matter about?
This matter is for quashing of FIR filed by the petitioner's daughter-in-law. She is alleging that there was some misappropriation of property by the petitioner.
Okay. That is a daughter-in-law, and then the fight between the Mother-in-law and the daughter-in-law.
Yes, and
With regard to
also she
feminine
has
property.
the FIR also names the petitioner's daughter
Yes,
and
yes.
her son.
You are appearing for the private respondent.
For respondent number 4,
Right. There is only one private respondent. Rest are- Who is appearing for the state?
Yes, my lord. Mr. H. Karvi is actually appearing in the case.
Somebody should there be
Yes,
present,
I am there.
otherwise we will say that none appears.
I'm there.
So you want some more time?
Some more time, maybe 2 weeks.
Any objection? Okay. The learned counsel for the petitioner prays for. See, this is pending for to say whether you will find a reject. It is. This is a matter where I don't think you will be. It will be there will be any requirement of filing a rejoinder. This is a criminal petition, so no question of filing a rejoinder.
Yes, my lord, I understand. But, we may kindly be allowed 2 weeks time to come back with proper instructions.
The counsel for the petitioner 6 grant of some more time for 20 necessary instruction in the matter. The prayer has not been opposed by the learned counsels appearing with the respondent. Prayer allowed, list up to 2 weeks. Yes.
Item number 2 and 3 are connected. Item number 2 and 3 are connected.
Same order?
Yes.
Same counsels?
Yes.
Yes.
I
Same
know.
order.
Item number 4.
Meet please, your lordship.
Yes.
Lordship, in this matter we are supposed to file rejoinder. In this matter we are supposed to file rejoinder to the affidavit of file be the respondent number 7, your lordship.
Who was supposed to file rejoinder? You?
Yes, your lordship. I humbly prayed for further 2 weeks time, your lordship, to file the rejoinder.
Rejoinder against affidavit of
Respondent 7, Your Lordship.
respondent number 7.
Yes, Your Lordship.
What is this matter about?
This is with regard to Kambura, Your Lordship.
This is about the appointment of the Gavuda. They have challenged, my lord. Now, the appeal lies before the CEM. Now, CEM was acting as a board, as per the Assam Land and Revenue Regulation, my lord. CEM individually, he was acting as a board, my lord, and he
He
passed
was a
it
part of the board which decided.
Yes, yes.
So he could not have sat there in appeal.
No, my lord.
Then?
It is the EM order which was challenged before the board. And in the board, CEM is not sitting as a CEM, he is acting as a board itself. So that order is under challenge, my lord.
No, then normally, and against EM's order,
Yes, my lord.
where challenge lies?
If it is a revenue matter, my lord, there are two types of matter which are placed before the EM. First is NOCMA. Then it goes to the CEM as in an appeal, my lord, as per the customary law.
Revenue matters means land and all, you see.
Yes.
It
But,
goes before the board.
Before the board.
So it went before the board.
Yeah, it is
Board
not-
has decided.
Board has decided.
So what
my
is the
lord.
illegality then?
That is what, my lord, they have to figure it out.
Just I want to say the board had no jurisdiction.
Yes, one of the argument they have placed in.
Okay. Okay. Anyway, but then see,
But this has no relation with the other matter, my lord. I don't know why it was tagged. Probably it was on the submission of Mr. Ranjit. So I don't know for what they have tagged, my lord.
the late Ranjit Kar was the counsel here.
Yeah, he was the counsel in the other matter, my lord. Next item.
How many affidavits has been filed here? Is something official? Watch, not only in the evidence. Okay. So till now you have not filed. See, you were okay. It is more than a month. That is going to be 2 months almost for filing a rejoinder against 107. Okay.
That's 2017 matter also, my lord.
That is the problem, you see. Most of the matters are like that. Okay, Mr. B. Kharwan Lanet. Oh, Mr.
Kriyam. Yes, Kriyam, Your Lordship.
Snaitam.
Kriyam, Your Lordship.
Karim.
Yes, Lordship.
Don't mind, my memory is very weak. Not counsel appealing for the petitioner. Prays for grant of some more time for filing a rejoinder against the affidavit in opposition of the respondent number 7. The counsel for the respondents have no objection. Prayer alert, at least after 2 weeks. You do it, you do not take time again and again.
6 and 7, Your Lordship. 6 and 7, Your Lordship.
Same.
No,
Lordship,
not
but
same,
with
my
regard to item 7, we won't file a rejoinder, Your Lordship.
There also affidavit is needed, no?
Yes, Your Lordship.
Readings are completed, my lord. And item 7 is about cancellation of a patta. Whether the cancellation was proper or
These
not.
matters are tagged together.
Yeah, my lord.
Why?
That's what I was submitting, my lord.
This is
I
a
am not
problem,
aware.
then it will create problem for the court, you see.
Here, my lord, the issue is this, my lord, that the patta was issued to the respondent by the district council, my lord. Now,
It can be hard separately. It means.
yes, my lord.
So, but then we have to again detach it. We have to segregate it again.
Otherwise, it has no link whatsoever with the item number 6, my lord.
Item number 6 is
By which order it is tagged together?
item 6.
No, by order when the order was passed.
There's an order.
Do you have that thing? Let us see it has been done at whose request.
13 to 23.
13 to 23. This is matter along with so and so, yes. That is the order, isn't it?
Yes, my lord. This
13.3, then 3.3.
The first order will be 20th July 22. 20th July 2022.
Why so many same order has been passed so many occasions? You have not pointed out. See, the court depends upon the lawyers. The counsels do not point out. Here it happened in matters where a matter court had passed order saying that no further adjournment will be given. But then it is seen that it is given because the next day it was this order was never pointed out.
Yes.
So that is what happens. You said when? What is the date of order? June.
July, 20th July.
20th July. 2022. There is no. Is there 28th July? There is 21st July. There is order.
In item 7.
Achha. Item 7. We are holding item 7 only. WPC 59.
Yes, yes, ma'am.
There is no order of 20th. 21st is there. 21 7.
July 2022.
21 7 2020. 21 7.
So I have a 20th order.
How can there be 20th order? Are there are 20th order also?
Also because it was listed thereafter.
Okay. But then it was linked to the review petition. There was a review petition pending.
Yes, 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 ma'am.
Lordship, in item 6, what had happened, our right for filing the matter was disposed of. Then we file a review, the respondent in item 6. That review was allowed. So this is the review matter. It's connecting to item 6.
But then here mention was made that it is connected to this review petition also.
But the review is already allowed.
No, that is okay, but then submission was made that this matter is also connected with review. Review petition is connected with the item number 6, isn't it?
The review was filed in item 6.
Definitely. So, but then here if you see this order dated 27 2020, so the learned counsel of the petition submits the matter is linked with review petition number 7.
Only submission by the petitioner.
So
There are a number of orders.
that is how, but then there is nothing to show that you have disputed that submission.
So there is nothing, my lord.
You have not disputed.
And initially it was
So
tagged.
here not filing any rejoinder. Here the question of filing rejoinder
No.
is not there.
This matter can be heard, my lord.
Anyway, so long it is tagged together, you will have to segregate it again, pass some order, segregating it, then
On the
only you
next
can
date,
take
we
it.
can point it out, my lord. All these orders by which this has been tagged together, my lord. So the order, because if we just point out one order, my lord, and there are subsequent orders also, then, my lord, it will be difficult to detag it, my lord. So if we can
It's like we have to pass some order saying that the councils submit that this is not connected. But then this has matter proceeded so long with these things. Let us just see. Hope let them file it at the stage of hearing. If it is required, then we can do it. Just the request of the petitioner, and this is matter after same. The previous matter is 2 weeks, na? Yes. 1 week. You said 1 week for filing rejoinder.
2 weeks, your lordship.
No, item 6. 2 weeks. So these also for 2 weeks. Yes.
Item number 8.
Yes.
May I please late. Lordship, in this matter, we are supposed to come with instruction, your lordship. However, we are still awaiting for the instruction, your lordship.
See, you will wait for long. You will take 1 decade for instruction. No instruction. We'll just argue. Forget it. This what to do. This is this. There nothing remains in this case. Argue the matter. We'll finish it.
Lordship, 1 week may be granted, your lordship.
You see, it's very unfair on your part. You keep on taking time
My apology, your lordship.
on the same route again and again. You take time for 1 week, and then with that you will go for 1 year. This is something doesn't look nice.
Lordship, kindly one more opportunity may be granted, your lordship.
At the request of the petitioner.
Let it be after 4
You are there also.
Respondents 8 and 9.
Who are there? Respondent number 8 and 9 is municipal.
We have no role. We are just.
The pro forma party.
No, my lord. On the direction of the government, we then remove the hoardings.
So it has been removed, and that was done long back.
Yes. So many years back.
So that situation cannot be revived back, is it?
No.
They can claim compensation.
And there's no challenge to any policy or
So that is what we can close it by saying that they will have the liberty to claim compensation in the event that they found that. That is one option for you.
One more push. Trustee Lodge.
The request of the petitioner is this matter after 2 weeks. Do it, you see, take the instruction, you see, like, do not make this court to behave in a harsh way.
My
It
apologies.
doesn't go nice with the court also.
Item number 10.
Yes.
Madam, I'm paying for short accommodation. Learned AG is on legs before the other court. Let this matter come at the end of the board, my lord.
Which AG is appearing here?
My lord, Ndishula.
What is the matter about here?
This is on pay parity with respect to an employee in the Juwai Municipal Board. The post is community organizer. Now, these posts of community organizers is all over the state in all the municipals. So my contention is that my pay should be at par with the others.
So what is to be done?
My lord, I'm praying for accommodation till the end of the board, my lord.
End of the board.
My lord.
You're ready to take up.
My lord, AG is ready, my lord.
So he's ready, isn't it?
He's before the other court, my lord. His matter is
Otherwise, he will take up the matter.
He's willing to take up the matter. He's ready, my lord.
So we'll have it at the end of the board. At the end of the board.
Item number 11.
Yes.
My lord, this is that matter, my lord, where they have raised an objection saying that there's a my lord, alternate remedy of appeal. This is that EPF matter, my lord. Lord, can we have this matter on Monday, my lord? I just need to only satisfy your lordship on that very point. That in spite of
If
there
any
being,
appeal lies, you go there.
my lord, here that objection ought to have been raised at the first instant. That was not done.
You see, just because objection comes at late, it doesn't mean that writ petition becomes
No,
entertainable.
that is correct, my lord. I bow down to your lordship.
See,
Only
the scope of judicial review would be narrower than the jurisdiction of
my lord, but my lord, the filing of a writ petition before a constitutional court, my lord, it's not. The bar is not absolute, even if there is an alternate
No, it
remedy.
depends. There is a wide discretion vested with the
That
court.
is what, my lord. That
If you can
discretion,
make
I
out
only need to.
make out a case for interference under 226, that is okay. But then in such a case, you have to.
I have to
point out
satisfy, my lord, why.
the procedural aspects mostly.
Absolutely, my lord. Only praying, my lord, if can we have this on Monday, my lord, subject to your lordship's kind convenience.
Monday.
Just
all-
try and
everyone
satisfy
was-
your lordship on that very issue, or else. my
Yes, madam.
Just let me check, Lordship, whether Monday I have any matter outside the district or not. Otherwise, I'll be
So we can have it after a week then.
because
Please finish these things.
My lord, I'll try and.
If there's is there any time limit for preferring appeal?
Limitation Act will apply, Lordship. That's
Limitation Act will apply. So
That has to
definitely
be-
Section 5 condonation also will come. So they will have that. Then we will observe that should be constitutionally
Waived.
valid. So take a decision.
My lord.
Why to lose one forum also?
My lord, in case if we are unable to satisfy your lordship, perhaps we'll take that liberty
See,
to file an appeal.
normally, so far as this court is concerned, in 226, this court doesn't run into the merits of matter.
Well, there are certain aspects which your lordship
Merits,
will
the
have to.
factual aspects and all those things. If you can say that there is a clear abuse of process of law and all those things, definitely. But then otherwise not. If it is claim is based on merits, okay, then
I'll try and satisfy, my lord, my submission on those parameters which.
yes, 1 week.
Lordship, okay, Lordship.
Or 1 week, after a week will be all right for you.
After a week, provided not Wednesday, Lordship, because I have Nongpo all the.
Today is Thursday, so after a week not come Wednesday. It will be lesser than a week.
Perhaps on Friday.
Yes, on the request of the petitioner list after a week.
Obliged.
Item number 12.
Yes.
On the last occasion, I was required to obtain certain instructions from the managing committee of the school. However, Lordship, I'm praying for weeks.
What is that matter about? This court has see so many matters. You see, like the
This matter relates to termination of the petitioner from the school, where he was serving as an contractual employee. Lordship.
this is not that matter where there exists two schools by the same.
Yes,
no.
yes.
No, no,
This
that was the thing. Court has asked the query for, they had prayed before the court for seeking instruction. The matter was heard. The court had posed certain questions on the basis of which they had asked for.
two inquiry report, my lord.
So many questions came up, which the court had posed the questions. So, as a matter of fact, they had said that they would be requiring some instruction on that. So, let them have their version. What is on the questions that the court had raised regarding the termination and at the same time.
This matter went to okay. This matter was listed before Honorable Chief Justice also. And then thereafter, yes, it came back again.
And it was heard at length.
And then you prayed for time for taking some instruction.
During the course of the hearing, Lordship, it transpired that he needed some instructions, and then the matter was.
What are those things? This court has forgotten.
Lordship, I'm praying if this matter can be taken up next week, Lordship. And one more prayer, Lordship. I'm praying I may be allowed to bring on record certain documents, Lordship, by open additional evidence.
See, filing, if we allow you to file an additional affidavit at this stage, then again the petitioner may have to reply to you.
Just to bring on record the certain
You just procure those things. We'll just see at the stage of hearing if it is needed. Then only we'll allow. We'll just see. These are all what this public document.
Lordship, public document.
So we may not have to file this thing also. There is always presumption of truthfulness of this public document. Just Mr. Chanda, Learned Counsel, appear for the respond number. You are appearing for?
I'm reading for 7 and 9.
No, 7 and 9. Praise for grant of some more time.
Lordship, also, Lordship, a copy of the affidavit filed by the state respondents may be given to me, Lordship. I have not.
That you ask for him. Why you want a judicial order for that?
I've been repeatedly.
Mr. Hazarika, give him.
We are not obliged because we have already given to the petitioner.
It's okay. You give him. He will xerox and he will return back to you. What is the problem?
No
No,
problem.
Lordship, this is not appropriate, but I have been repeatedly requesting.
Do not. Nowadays, you see the court refrains from passing this kind of orders. You should have that much relation between you, isn't it? That cooperation is there. You see. Please give them a copy.
Okay.
If you do not have extra copy, give your copy. They will xerox and return it back to you. Mr. Chandra, Learned Counsel, appear on the resolution number 7 and 9. Praise for grant of further time, enabling him to obtain some vital instruction in this matter. Some instruction in this matter. The Learned Counsel appearing with the petitioner has no objection. Accordingly, release this matter.
After 2 weeks.
You will have it after a week. Do not make it. See, you take it as after a week. After a week, this is matter. We'll have it after a week, Mr.
Item number 13.
Yes.
Lordship, I'm praying for some accommodation, Lordship, in this matter.
It's a new matters.
Quite new matter.
Until unless there is urgency on your part. When do you want it?
After 2 weeks, Lordship.
You have it after 6 months at a time? Mr. Snaitang, Landed Council, appear for the petitioner. Praise for grant of 2 weeks time. Mr. Gautam Lanai, Council, appears the respondent has no objection. They are allowed least after 2 weeks.
We are blessed. Obliged.
Second call, item number 10.
Lord, Mr. Shulai has just informed me that he's in a part-heard matter, my Lord. Lord, matter may come up next Thursday, my Lord, on joint request.
It will come up after a week.
After a week, my Lord.
And the request of the state respondent.
My Lord, I appear for the state respondents.
So the request is from the state respondent to a...
My Lord, it's a joint request, my Lord. Senior counsel has spoken to the petitioner counsel.
Oh, he is ready.
My Lord, the only thing is, sir, is also in a part-heard matter as he has submitted.
Let it be a joint request. It's okay, my Lord.
On the joint
He is a
request.
senior counsel.
It's all right. We can understand this.
Joint request, my Lord.
Allow sometimes the court also to interact.
My Lord, my Lord. Apologies, my Lord.
The joint request list is matter after a week. You are also there. Nothing more. After a week?